Josh, Mark, the three of us, we were all in the courtroom today for arguments. So let's start first with your main takeaways. Josh, I'm going to start with you.
Well, I thought it had to be a dispiriting day for Special Counsel Jack Smith. He saw one after another of the members of the conservative majority on the court basically signal discomfort with his position and some degree of alignment with Trump's claim that there should be at least some type of immunity or protection for a former president from criminal charges. I have sort of a vivid memory of sitting there and having each of those justices. I'm thinking of Justice Brett Kavanaugh, Chief Justice John Roberts, and Justice Neil Gorsuch, for example, go through one by one and make pretty clear that they were not going to come out in this case the way Jack Smith wants them to come out. And at that point, it's a numbers game that I don't think looks too good for him.
You know, Mark, were you as surprised as I was to hear the line of questioning that came out of some of the more conservative justices like Brett Kavanaugh and Neil Gorsuch and Samuel Alito?
I was. And the sense that I got from those justices was that to them, to their minds, the real threat to democracy was not Trump's effort on January 6th to overturn a free and fair presidential election. The true threat to democracy is the Justice Department's effort to hold him accountable for that act. And I did not expect this kind of minimization of January 6th that we saw from the justices. Frankly, my sense is that the conservative bloc just didn't think that the insurrection at the Capitol was that big of a deal. And so instead of hearing concern about what it would mean to let the president off scot-free for allegedly plotting and facilitating this violent election subversion, we heard these justices try to say, well, let's talk about the abstract principles here. Don't we need presidents to act boldly and fearlessly? As though we haven't seen an object lesson in what happens when a president thinks he's unaccountable. And as if we aren't here, you know, in this hearing, in this case, to try to decide whether or not, as a democracy, this country is going to say even the president is not himself above the law.
You know, Joyce, Judge Lugo pointing out on social media that the court and the parties discussed everything but the specific question at hand. Even Justice Ketanji Brown Jackson, in my opinion, kind of got to the heart of that matter as well during arguments, Joyce, when she asked Dreeben, who represents the government, she's like, why can't we just answer the question that's been presented? Because everybody was dancing around it, to Mark's point. Joyce, is there a reason why the court actually didn't try to address the question presented?
So this was an unusual argument in a lot of ways, Katie. Not only did they have trouble coming to the point of the question that they themselves wrote for this argument, they also had a lot of trouble talking about Donald Trump. This was a court that was very focused on the impact that whatever decision they reach would have in the future and on future presidents, and really not particularly interested in talking about Donald Trump. You know, you and I have both been around a lot of criminal appellate arguments, and I don't think I've ever had an argument that didn't focus at least in part on the defendant and his conduct and how the ruling would impact him. But here that didn't seem to be the focus. The court was supposed to take up the issue of whether the president had immunity from official acts, and if so, what the scope of that immunity was. And instead, we were far afield and all over the board. Everything from this issue of whether presidents had to be specifically included in a criminal statute before they could be prosecuted. On the other hand, to whether or not, you know, presidents' personal acts could be prosecuted, which was something, frankly, that Trump's lawyer conceded up front. And so why that was ever on the table was very confusing. But Justice Alito had proposed this alternative test, and the conversation really went far afield. It was a very messy argument.
You know, Peter, take a quick listen to what Jamie Raskin had to say on how things went at the Supreme Court today.
There are politicians who are not even subject to popular election, unlike me. They should move the Supreme Court over to the RNC headquarters because they're acting like a bunch of partisan operatives.
I mean, Peter, this is not the first time we've heard criticism that the highest court in the land has been hyper-politicized. Considering the substance of the arguments today, does this particular case kind of, raise even more questions about the credibility of SCOTUS?
Well, it'll certainly create a lot of concern and conversation about it, and it'll create some criticism, as the kind you just saw from Congressman Raskin. Let's go back and look at history for a second. When the Supreme Court was presented with the question of whether Richard Nixon could withhold the tapes from the Watergate special prosecutor, the Chief Justice at the time, Warren Burger, thought it was important enough that the court would speak with a single voice. He forged an 8-0 unanimous verdict because he didn't want there to be a perception that there were differences depending on partisan backgrounds and who might have appointed you and all that kind of thing. Similarly, when the court was presented the question during Bill Clinton's presidency whether a president should be immune from a civil lawsuit, in his case a sexual harassment lawsuit filed by Paula Jones, the court again spoke with a single voice, 9-0. It said no, a president doesn't have immunity from a civil lawsuit. Here what we're looking at is the potential for a split verdict, a 5-4, 6-3 kind of verdict in which the conservatives are largely on one side and the liberals are largely on the other side, which will, of course, then encourage the notion that this is just ideological, it's just partisan, it's just political, it's not really a detached view of the law, and therefore will not have the same power that those previous verdicts had. And I think that's the danger. And I think Chief Justice Roberts, who has historically expressed concern about the credibility of the court as an apolitical institution, faces another challenge here as we watch to see what kind of a ruling they come back with.
Josh, I wanted to ask you something that I picked up on, and I want to know if you heard it. There was some conversation, albeit minor, about Section 1512, and this idea of the definition of when somebody in a defendant state does something corruptly. We've heard this applied to the January 6 rioters and the prosecutions of them, but we also know that that dovetails with the prosecution of Donald Trump. Did you pick up on that and the fact that it sounded maybe a little bit ominous about the future of those prosecutions, including that of Donald Trump?
Right. Well, as you know, Katie, we have a related issue there involving those prosecutions that's already pending in front of the court, was already argued. Today's arguments on the Trump case were the final arguments of the term. And it sounded to me, based on the comments of Justice Neil Gorsuch, who I think you may be alluding to, that the court has kind of made up its mind that there is a problem with using this obstruction charge in connection with the events of January 6th. That problem might extend to using it in a couple counts of the 4 counts against former President Donald Trump. And Gorsuch zeroed in on the word corruptly that appears in that obstruction statute. And he said something like, nobody really knows what that means. Well, goodness, when someone on the Supreme Court is saying that some term in a criminal charge that's been used in a lot of cases, nobody really knows what it means, it does not bode well for Jack Smith being able to use that charge against former President Trump sometime in the coming months.
Yeah, and you're right, and it was Gorsuch who made that statement, and it kind of stood out to me because I was worried about what it meant. Joyce, let's talk about this proposed rubric that was discussed, kicking the case perhaps back to the trial court in front of Judge Chutkan, and then allowing for this parsing out of what is an official act versus a private act. And then if you were to follow kind of the logic of some of the conservative justices, you would end up prosecuting only the personal or the private acts, because those would be violative of the law. But the official acts, Donald Trump and others or presidents, would be able to get immunity. Talk about how fatally flawed this is going to be. I'm putting aside the delay, because we all know that it bakes in delay. But in terms of the legal analysis, talk about the problems that are generated by trying to do that type of, I guess, different approach to this particular indictment.
So first, I don't want to be unduly optimistic, Katie, but I'll pump the brakes a little bit on speculation. Sometimes the final opinion that the court issues has very little resemblance to what goes on in oral argument. It's always dangerous to read the tea leaves too heavily. Sometimes the justices are talking with each other in oral argument as much as they are with the litigants trying on arguments for size. So it's possible that we won't see this possibility that you're talking about pan out. You know, I felt the same way about Justice Gorsuch's comments about 1512 and the state of mind. I took it to think maybe he had come out on the losing end of that battle on the 1512 obstruction of an official proceeding case, and maybe he was expressing some sour grapes. So we'll see. But the argument that you're talking about is one where the justices would issue some sort of a rule that established some way of evaluating what conduct by a president was official and what was private. I think about this in terms of Trump acting as President Trump on the one hand and as candidate Trump on the other hand. That would then go back down to the lower court for Justice Chutkan, presumably to make a ruling. I suppose they could also decide to send it back to the Court of Appeals, but Trump's lawyer, John Sauer, suggested it should go back to the district judge. Mm-hmm. You know, the silver lining here, though, is for her to make that decision. She could decide she needs to hold an evidentiary hearing and put on a mini trial, in essence, before she made that determination. It would be cumbersome. It would be subject to additional layers of appeal, most likely. It would, as you mentioned, engender a lot of delay. But there is this slightly rosy prospect of actually having a hearing, even though there wouldn't be a jury verdict, a hearing where the government's evidence would become public.